Hi everybody, it's Andy, and welcome again to my office in Los Altos, California. I'm an attorney licensed to practice law in California as well as New York. In this video, I'm going to go over a contract law concept called the Statute of Frauds. Now, I'm going to specifically talk about the California Statute of Frauds. If you hang out with me to the very end of the video, I'm going to talk about it. But the basic idea of the Statute of Frauds is not unique to California. Other states in the U.S. have it also. If you are outside of the United States, and I know that some of you are, I don't know, I guess, country by country whether or not the Statute of Frauds exists. I also don't know which country you're watching me from. So my usual advice, I guess, for looking stuff up outside the United States is that you basically have to check whether or not what I'm talking about applies in your country. So this video is going to be California specific, but hopefully, I guess, it should give you some ideas about what to do research on for your particular situation. So all of that said then, despite having, I guess, somewhat of an intimidating name, the Statute of Frauds concept is actually fairly simple. Basically, it says that, regardless of what the parties may want, regardless of what might seem sort of common sense, I guess, under a situation, the law requires that certain contracts have to be in writing. A verbal agreement, not enough. A handshake deal, not enough. A writing has to exist. So now, practically speaking, it's not going to be a big deal usually to write something down. Just take a few minutes, write it down, whatever. It's not usually a big deal. Practically speaking, it can be sort of an awkward thing to do, though. So the thing is, if you have a contract where if you have an agreement rather, that you are negotiating with somebody, you've done business with them before, they might be somebody who you are really trying to curry favor with. To basically ask them for something in writing might seem like, you're saying that, you don't trust them, or that you think that they're going to, cheat you or something. All of that stuff aside, though, the Statute of Frauds does basically require require a writing anyway. So it is something, unfortunately, that you are going to have to basically deal with. Find a way to basically ask for the writing somehow. So hopefully all of that made sense. The basic idea behind the Statute of Frauds is, like I said, not unique to California, but I am going to talk about the California one in more detail. If you hang out with me to the very end here in just a second. But before I do that, I'll ask you guys again, of course, to comment, subscribe, share, like, all that nice stuff. Yeah. So anyway, so all of that said then, I'll go ahead and discuss the California Statute of Frauds right now. So the Statute of Frauds requires that certain contracts have to be in writing in order to be enforceable. This is an exception to the general rule in California that contracts do not have to be in writing. They can be oral. This is under Civil Code Section 1622, which I will paste and link down in the description below for you. I guess aside from what the statutes actually require, I think a lot of us probably have, horror stories, life experience, etc., that basically tell us that, an oral agreement is not, nearly as good as a written contract. So, even though a written contract is not required in, most cases, you should try to get one anyway. The Statute of Frauds idea just basically pushes that principle one step further to say that, under these situations, these limited situations, you absolutely have to get this in writing. So the word writing under the Statute of Frauds actually has a fairly broad definition also. You don't have to have a written document that is actually signed and dated by each party. It's helpful if you do, and if you can do that, by all means do that. But you can use other means as well, text messages, emails, etc., to prove that a writing was actually made. So this idea of a statute of frauds is not specific to California. Most U.S. states will have a version of it. But the big caveat here is that if you are not in California, this video does not apply to you. So you have to read the statute or statutes in your state to see what your statute of frauds requires in terms of criteria, what exceptions apply, etc. In California, the statute of frauds is under Civil Code Section 1624, which I will go ahead and paste and link down below in the description for you also. But if you read 1624, it's fairly long, but if you read it, there are 7 situations in California where the statute of frauds absolutely requires a writing in order to make the contract enforceable. Those 7 situations are not exhaustive, meaning that there are other situations, or sorry, other statutes rather, under California law that also impose requirements that agreements be in writing. As far as I'm able to tell, there is no kind of logic or rhyme or reason as to how those other statutes are laid out. They appear random to me, like that just a lot of stuff in California statutes is random like that. But if you know of a reason why those statutes are laid out the way they are, go ahead and leave me a comment, or otherwise let me know. So hopefully all of that made sense. I'm going to go ahead and go over, hopefully some at least, of the 7 situations that the California Statute of Frauds requires a writing for. So the first one is an agreement that by its terms can't be performed within 1 year of its making. The basic idea here is that if a contract is made and performing, either party performing under the contract is physically impossible within 1 year, like, it would require time travel or cloning or something that basically cannot be done, that agreement has to be in writing in order to be enforced. Number 2 is that if you are guaranteeing or promising to pay another person's debts, that agreement has to be in writing also, subject to any exception that might apply under Civil Code Section 2794, which again I will also paste and link down below in the description. Number 3 and number 4 actually read very similarly. Number 3 is an agreement to sell real estate or lease real estate for a period longer than a year. What they're talking about here, like the agreement they're talking about here basically, is the agreement between the buyer and the seller, for example, or the landlord and the tenant. The agent's signature of, like, basically to have the buyer's agent sign for him, if they're buying real estate, that is not sufficient. The seller's agent signing for the seller, that's not sufficient. Landlord's agent, tenant's agent, the agent's signature is not sufficient. Number 4 actually refers to the agreement between the buyer and the buyer's agent, if there is one, the seller and the seller's agent. So number 3 basically refers to the agreement between the 2 sides of the transaction. And number 4 refers to the agreement between, I guess, either side of the transaction and the agent representing them. Number 5 is an agreement that by its terms cannot be performed within the promisor's lifetime. The promisor basically is the party to the contract that, or the party to the agreement rather, that is charged with doing something. Like, they're the one who has to do something under the terms of the agreement. If that agreement cannot be performed within that person's lifetime, that agreement has to be in writing in order to be enforced. Number 6, I'm not going to talk about a whole lot. I think basically the idea is that, if you are buying a piece of real estate and you're assuming a mortgage obligation with it, that obligation has to be in writing in order to be enforced. I think that's pretty common sense, I guess, based. Hopefully that should make sense to everybody. Number 7 is that, if a loan is being made or credit is being extended where the amount extended is more than $100,000, that loan or that credit has to be, put into writing, mainly because, if it's not, then the lender has no way of enforcing, repayment if the borrower doesn't. Yeah. So all of that said, hopefully, it all made sense. But the last point I want to emphasize again is that under the statute of frauds, because it is so limited, precise language is very, very, very important. So if you are in California, I don't mean for this video to be an exhaustive kind of, I guess, exercise or kind of review of the statute of frauds. If you're wondering whether or not, for example, your loan qualifies, under number 7, you have to go and read the actual statute. 1624 of the Civil Code. You have to look at that because I have not copied it word for word. Yeah, this video is just to kind of introduce the idea and kind of go over it briefly. And if you are in other states, not California, as I said a moment ago, you definitely have to read the statute, the code sections, whatever it's called, in your state to see what requirements your statute of frauds has, what criteria, what exceptions, all that stuff. So hopefully all of that made sense. the takeaway here is that, in general, in California, contracts can be oral. A writing is not required, although, as we discussed, it's a very good idea to have it anyway. In very limited circumstances, the statute of frauds says that a writing is absolutely required. Yeah. So the thing is, if you fall under any one of the 7, then you absolutely have to have a writing. And if you don't, and you're trying to enforce the contract to make the other person do something under the contract, you can't, basically, because you don't have a writing. So hopefully all of that made sense. Go ahead and share this video, like, subscribe, comment, all that nice stuff. And I will talk to you next time. Thanks.